Jury Supreme Court of the State of New York County of New York, Criminal Term Part 59 T People of the State of New York X Indictment Number 71543-2023 against Donald J. Trump, falsifying business records first degree defendant, X 100, Center Street, New York, 10013 April 26, 2024 before Honorable Juan M. Merchant, Justice Appearances, for the people, Alvin L. Bragg, Jr., ESQ, District Attorney, New York County BY, Joshua Steinglass, ESQ, Matthew Colangelo, ESQ, Susan Hoffinger, ESQ. Christopher Conroy, ESQ, Rebecca Mangold, ESQ, Catherine Ellis, ESQ. For the defense, Blanche Law by Todd Blanche, ESQ, Emile Bove, ESQ, Netchley's Law, LLP by Susan Netchley's, ESQ, Gedalia M. Stern, ESQ. Susan Pierce, Bates Principal Court Reporter Lori Eisenberg, Lisa Kramsky, Teresa Magnacari, Senior Court Reporters Lori Eisenberg, CSR, RPR Senior Court Reporter The Clerk, continuing case on trial, People vs. Donald J. Trump. Appearances, starting with the people. Emarja Steinglass, for the people, ADA Joshua Steinglass, Susan Hoffinger, Matthew Colangelo, Christopher Conroy, Becky Mangold, and Catherine Ellis. Emar. Bove, Emile Bove for President Trump, seated to my left. I'm joined by Todd Blanche, Susan Netchley's, and Gedalia Stern. The court, good morning. A couple of things to go over. Regarding next week's hearing, I think you received my email. We're changing the time of that from Wednesday at 2:15 to Thursday at 9:30. I also wanted to go over the issue regarding the text from Dylan Howard you wanted me to look at. We spoke about it yesterday. Mr. Steinglass, to the extent that it may inform your Honor's opinion, we sent counsel, last night, some proposed redactions to remove what I think whether you'll review those concerns, and I believe that the court read the submissions, including all the legal authority that was handed up. I also read the relevant portions of the transcript, which were pages 1221 through 1226. I note on page 123, Mr. Bove, at line 20, says, I think we're basically on the same page. And then, on 1224, you express your concern. Your concern is, at some point, cumulatively, it becomes cumulatively prejudicial. So, I appreciate your concern, and I agree that there could come a point where it will possibly become prejudicial. The difficulty is, I don't know at this point what that's going to be. So we're just going to have to keep going through it. You'll make your objections. I'll consider the objections. And at some point, we may get there. I am relying, primarily, on People v. Settles, SETTLES, 46N.Y.2d. 154, at page 169. This is a Court of Appeals decision. Naturally, there can be no precise demarcation or formulation of the proof which will constitute sufficient support of evidence of a declaration against penal interests. By its very nature, the determination involves a delicate balance of diverse factors and is entrusted to the sound judgment of the trial court, which is aptly suited to weigh the circumstances surrounding the declaration and the evidence used to bolster its reliability. So, that's really what's going to guide this court, but the fact that you said you're pretty much on the same page, we're in agreement with who is a co-conspirator in this case, Dylan Howard. We're in agreement that at least some, if not most, of the responses are coming in for some purpose. And we're also in agreement that there will be redactions to that. Mr. Bove, yes, Judge. Thank you. I appreciate and understand all of that. Just for the record, when you said we're in agreement about who's a co-conspirator, we understand the court's ruling, and we're abiding by it. Our objection has been noted. And I will confer with Mr. Steinglass and the government over the weekend about the proposed redactions, and we'll get back to the court on Tuesday. The court, of course. Once you do that, please let me know what you suggest the instruction should be to the jury. What is it they're considering that other language for? Mr. Bove, yes, Judge. Thank you. The court, we're going to break today at 12:30 to hear the people's motion to compel. Mr. Colangelo, thank you. One update on that. After further discussions with the third party's counsel this morning, we think we no longer need the court's intervention on that today. We will bring it to your attention should it become necessary. The court, great. We'll go to 1 o'clock. Is there anything else? Mr. Steinglass, there's a few things. First, is Your Honor going to address the issue with the jury that was raised at the end of the day about what we consider to be improper impeachment by omission by Mr. Bove? The court, would you like to be heard, Mr. Bove? Mr. Bove, yes, Judge. Just to clarify, my intentions for this morning on this issue are to begin by basically saying to Mr. Pecker, I apologize for any confusion about that, clarify a little bit about his relationship with Ms. Hicks, and move on. There's grand jury testimony on this issue for where a specific question was asked. I'll draw the witness' attention to that and go through it. I've reviewed Bornholt and its authorities, and I'll lay a proper foundation. The court, thank you. I think that's sufficient to address the issue. Mr. Steinglass, next. Whatever Mr. Bove's intentions were with regard to the questions about prior meetings with the DA's office and reviewing materials, I think that he left a misleading impression that contact was somehow improper, and I don't think it would be appropriate to wait until the end of the case to give the CJI instruction on pretrial preparation. I'm handing it up to the court. The court has been very reasonable about giving mid-trial curative instructions or limiting instructions, and I would ask that you give this instruction to the jury this morning. The court, any objections? Mr. Bove, may I have just one moment, Judge? The court, sure. Mr. Bove, Judge, I think there was instruction along these lines in your preliminary instructions, so I think the jury is aware of this issue. I'm not sure it's necessary. There was a brief reference to it. The court was very brief, if I remember. I advise you, it's common or permissible for the prosecutor and counsel to meet with witnesses before they testify. I believe that was, pretty much, what I said. So, I can give this instruction just to modify. Mr. Stanglass, okay. I also have a proposed instruction. It doesn't have to be given today. But, it's an instruction on redaction, so the jury doesn't draw any improper inferences from the fact that certain material, personal material or otherwise material that the parties have agreed is irrelevant should not be before the jury or is prejudicial, so that the jury doesn't draw any improper inferences from the existence of those redactions. Next. I think, again, whether intentionally or unintentionally, Mr. Bove's questioning yesterday improperly conflated the federal prosecutors and state prosecutors, referring to both as the government. Of course, that's, the state prosecutors are referred to as the people. I am not telling Mr. Bove how to refer to us, that's how he chooses to refer to us. But I do think he needs to be clear when he's questioning the witness about prior interviews, which prosecutors he is talking about. So, if that's unclear from the question, I will object, and I just wanted to explain. That's fair, because there was more the court than one prosecutor's office involved here. Mr. Stanglass, thank you. Finally, Judge, I just want to bring the court's attention to that we caught a reference in People's 174A to a lie detector that was going to be taken live. I don't know if Your Honor noticed it when we had the witness on the stand. I don't think Your Honor precluded reference to the lie detector, just the results of the lie detector. We've taken a broad view of that and have redacted references where we've seen them. I notified counsel and swapped out a new version of 174A that contains a redaction just of the word lie detector. The court, is that it for the people? Mr. Stanglass, yes, Your Honor. The court, how about the defense? Mr. Bove, no, Your Honor. The court, okay. We can get the witness, please. OFFICER witness entering. Whereupon, the witness, David Pecker, having been previously duly sworn and or affirmed, resumes the witness stand and testifies as follows. The court, good morning, Mr. Pecker. Welcome back. I remind you that you're still under oath. Get the jury, please. Court officer, all rise. Jury entering. Whereupon, the jurors and the alternate jurors are present and properly seated. The clerk, continuing case on trial, People versus Donald J. Trump. All parties and all jurors are present. The court, good morning, jurors. Jurors, before we continue with the cross of Mr. Pecker, I wanted to give you an instruction regarding yesterday's testimony. You heard testimony yesterday about the prosecution speaking to Mr. Pecker about the case before the witness testified at this trial. The law permits the prosecution or an attorney to speak to a witness about a case before the witness testifies and permits the prosecution or an attorney to review with the witness the questions that will or may be asked at trial, including questions that may be asked on cross-examination. You have also heard testimony that a witness, Mr. Pecker, read or reviewed certain materials pertaining to this case before he testified at trial. The law permits a witness to do so. Speaking to a witness about his or her testimony and permitting a witness to review materials pertaining to the case before the witness testifies is a normal part of preparing for trial. It is not improper, as long as it is not suggested that the witness depart from the truth. Mr. Bove. Mr. Bove, thank you, Judge. Mr. Bove, may I inquire, Judge? The court, yes. Continued cross-examination by Mr. Bove. Good morning, Mr. Pecker. Good morning. When we were talking at the end of the day yesterday, we were speaking about a meeting with the federal prosecutors in August of 2018. Do you remember that? Yes, I do. Q, that was my fault. There was some confusion in the questioning about what had been said and whether Hope Hicks came up. Do you remember that? Eyes. From that. I want to apologize and move on to another meeting if I ask a bad question today. I think Mr. Stanglass will tell me, but you can as well, and we'll make sure that I'm clear. Thank you. As I said, we were talking about Hope Hicks. Right? Eyes. And you knew Ms. Hicks long before August of 2015, correct? I did. She had worked at Hiltzik Strategies? She did. That is a communication and strategy firm, correct? It is. They did some work for AMI? Yes, that's one of the ways you met Ms. Hicks, right? That's correct. I think you said she did some work for Star Magazine. Eyes, which was an AMI publication under your watch. Yes. You testified on Tuesday that she also worked as President Trump's communications director at some point. Eyes. So, what I was asking you about yesterday was your testimony in response to Mr. Stanglass' questions about whether Ms. Hicks was in that meeting in August of 2015, right? Eyes, that's correct. And to be fair, you said the ton direct that she was in and out of the meeting, right? That's what I said. It's not as if you suggested to the jury that she participated in the meeting, correct? That's correct. And you did not suggest to the jury that you have a recollection of her speaking during the meeting. Correct? That's absolutely correct. Now, you testified in federal grand jury proceedings, right? Eyes, and that was also in August of 2018, correct? Eyes. And it was about 2 weeks after the meeting that we were talking about at the end of the day yesterday, right? That's correct. Eyes. August 13th, 2018, does that sound right? And there was a court order there, right? Yes. Just like today? Yes, and you were under oath, correct? Eyes. Just like today? Just like today. And do you recall being asked the question, did you meet with Donald Trump and Michael Cohen, an employee of the Trump Organization, at Trump Tower? Do you recall that question? Mr. Stanglass, objection. The court sustained. Mr. Bove, if you are going to advise the witness to a particular portion of the transcript, please advise the prosecution so that they can turn to it. Mr. Bove, yes. Mr. Bernick, for the court, the parties, and Pecker, can we please bring up the document marked for identification as Exhibit A104? If we can go to page 5. Mr. Please and zoom in on lines 17 through 19. Whereupon, an exhibit is shown on the screen of the witness and the parties, and the witness reviews the exhibit. Sir, this is from your federal grand jury testimony, correct? Yes. Do you recall being asked this question? Yes, Mr. If we could zoom out, please, Mr. Bernick, and turn to the next page, page 6. Do you see at lines 6 and 7, you were asked to tell the grand jury what happened at this meeting? Ayes. When you were asked that question, you understood it was in reference to the August 2015 meeting, right? That's correct. And you answered the question, obviously, right? Could I see the answer? Yes, Mr. We can zoom out entirely, Mr. Bernick, and give Mr. Pecker an opportunity to review. Whereupon, the witness reviews the exhibit on his screen. You said it was 6 and 7? Yes, Mr. We can go to page 7 now, please. Whereupon, the witness reviews the exhibit on his screen. Let me know when you're done. Can we turn back to 6? Of course. Whereupon, the witness reviews the exhibit on his screen. The next page, please. Mr. Can you go to page 7 please, Mr. Bernick? Whereupon, the exhibit is shown on the witness screen and the party screens, and the witness reviews the exhibit. I read page 7. Mr. Page 8, please, Mr. Bernick. Whereupon, the exhibit is shown on the witness screen and the party screens, and the witness reviews the document. Okay. Page 8. Thank you. So those pages 5 through 8, constitute your answer about the August 2015 meeting, right? Ayes. During that testimony in August of 2018, you did not describe any specific statements made by Ms. Hicks, correct? Mr. Steinglass, objection. The court sustained. Let's talk a little bit about what was said during the August 2015 meeting. You said on your direct that there was discussion about Bill and Hillary Clinton, correct? Yes. And at the time of this meeting, August 2015, the National Enquirer was already running stories about Bill and Hillary Clinton. Correct? Ayes. That was going on before the meeting, right? That's correct. And that was because you had made a business decision that it was good for the National Enquirer to run those stories, correct? We talked about, yesterday, how you were going to the research meetings, right? I did. Yes, Ayes. And looking at the data? And thinking about what made sense from a business perspective for AMI. Correct. What was consistent with your fiduciary obligations at AMI? Ayes. So, before the August 2015 meeting, you made a decision that it made sense for AMI to run articles about Bill and Hillary Clinton, right? Yes, and those articles were negative, right? Yes, so, it was easy for you to say during the August 2015 meeting that you would continue to do that, right? Ayes. That no issue for you? No. We talked yesterday about things that were mutually beneficial. That was entirely beneficial to AMI? Mr. Steinglass, objection. The court sustained. Running those stories were beneficial to AMI. Correct? Running the stories were beneficial to AMI. Correct. And doing what was good for AMI was standard operating procedure? Ayes. Now, you testified on Tuesday that during this August 2015 meeting, there was also a discussion about running negative stories about President Trump's opponents, right? That's correct. And you testified that there was discussion of that topic during the August 2015 meeting. Do you remember that? Ayes. And 3 specific opponents, preliminary opponents, came up, right? Yes, Ben Carson, correct? Ayes. Marco Rubio, right? Right. And Ted Cruz, correct? Ayes. And you were shown some exhibits by the government that related to stories the National Enquirer ran about those 3 men, correct? That's correct. There wasn't much new content in those stories percent. B was there? I would have to reread the stories to answer that question. We'll take a look at the stories in a minute. But, let me ask you this, it was standard operating procedure for the National Enquirer to, sort of, recycle content from other publications and frame it slightly differently. Correct? Correct. That's cost effective? Correct. Information from the public domain goes into the National Enquirer. It's quick and easy. Correct? Ayes. Good for business? Yes. Consistent with your fiduciary obligations, correct? Yes. And for at least some of the articles that you testified about on Tuesday, that's exactly what you did, right? Ayes. There was already negative information in the public domain about Ben Carson, and so you ran it in the National Enquirer, right? Ayes. And because that was quick and efficient and cost-effective, you would have done that whether or not you had discussed it with President Trump, correct? Ayes. Mr. Bernick, if we could take a look at Government Exhibit 153A, please. This can be shown to the jury. This is in evidence. Mr. Pecker, this is one of the exhibits we looked at on Tuesday, right? Yes, and there are 5 headlines here relating to Ben Carson, correct? Ayes. And there's some dates on the page. Do you see them? Ayes. And the date range is, basically, from what I can tell, October 2015 to December of 2015. Right? Ayes. So, you see that there's an article, the top article on this page relates to some kind of issue with a surgery performed by Dr. Carson, right? Ayes, and in this time frame, 2015, you were leading AMI, right? Yes. And you were familiar with what was going on with